In every criminal trial, expert evidence is supposed to shine a light on the truth. But what if that evidence is wrong? What if lives, freedom and even justice itself depend on the very same science we trust to find the truth? In cases like Lucy Letby and Colin Norris, the use of expert medical evidence has been called into question. This is not a new issue. The tragic stories of Sally Clark and Angela Cannings exposed a systemic failure, one that put the wrong people behind bars and the truth further out of reach. But it's not just about the experts themselves, it's about a broken system that allows such conflicting, often ambiguous claims to carry weight in life-changing decisions. To restore trust in our justice system, we need more than just accountability for individual experts. We need a complete overhaul in how we vet, present and evaluate expert evidence. Isn't it time to rethink how science and law work together in our courts?
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. We have one warning only today. Things are about to get formal and legally serious. So dust off your wigs and black caps. In the first part of this video, we will lay out the indictment against the criminal justice system. In the second, we will examine the penalty it faces and the path it must take if redemption is still possible. In the court of public justice, the people v. the criminal justice system. The criminal justice system is charged as follows. Statement of offence. Failing to shield the court from the adversarial manipulation of science, contrary to Section 3 of the Spoken Injustice Act 2025. Particulars of offence: that the system has placed expert witnesses within the adversarial structure of criminal trials, resulting in dwelling experts, selective disclosure, and the manipulation of science for persuasive rather than truth-seeking purposes. Juries are left to adjudicate between competing scientific claims without sufficient understanding or impartial guidance, leading to verdicts shaped more by rhetorical skill than empirical strength. We will also take into account aggravating factors that, despite repeated miscarriages of justice and multiple public consultations, the system has failed to enact meaningful reform regarding the role, selection, and regulation of expert evidence, thereby perpetuating risks of wrongful convictions. Historical failures were ignored. Sally Clark, Angela Cannings, Donna Anthony, among others, all should have triggered urgent reform. The failure to establish independent expert panels, clear standard of admissibility, and judicial education of scientific principles remain inexcusable. Furthermore, the system continues to attribute errors to individual experts or isolated failures, thereby refusing to accept institutional responsibility for procedural flaws that enable such evidence to be misused, misinterpreted, or misunderstood. We, the accuser, do not seek vengeance, but reform. We call upon the court to recognize that the injustice lies not only in wrongful convictions, but in the structural conditions that allow unreliable expert evidence to influence verdicts at all. Until such time as the justice system accepts its complicity and enacts a systemic change, its claim to truth, fairness and integrity remains in doubt. And here is our opening note. Colin Norris, a nurse, was convicted in 2008 of murdering 4 elderly patients and attempting to murder a 5th in Leeds hospitals. The deaths were attributed to unexplained hypoglycemia, low blood sugar, which prosecutors argued was due to insulin poisoning. The prosecution's case relied heavily on statistical improbability and medical expert opinion, suggesting that the cluster of hypoglycemic events was unlikely to be natural. Key expert testimony asserted that spontaneous hypoglycemia in non-diabetic patients was extremely rare, implying intentional administration. Later reviews challenged the certainty of that expert consensus. New medical studies showed that spontaneous hypoglycemia was more common than previously thought, especially among frail elderly patients. The appeal, still ongoing, rests on fresh medical expert evidence that shows that spontaneous hypoglycemia is more common than previously thought, especially among frail elderly patients, thereby discrediting the original assumptions. Lucy Letby, a neonatal nurse, was convicted in 2023 of murdering 7 infants and attempting to murder 7 others at the Countess of Chester Hospital. Central to the case were medical expert interpretations of unusual collapses and death in the neonatal unit, many with no clear cause. Prosecution experts argued these were consistent with deliberate harm, including injections of air and insulin, which they claimed could not occur naturally. Defense countered that the infants were already critically ill and that hospital practices and conditions could explain the events. Some observers, including medical professionals, questioned the certainty with which ambiguous symptoms were interpreted as intentional harm. There were also concerns about confirmation bias and the limited scope of alternative explanations presented. Expert evidence was instrumental to securing conviction, but it also sparked debates about how courts interpret rare or unexplained medical events, especially when physical evidence is limited. Peter Sullivan was convicted in 1987 of the rape and murder of Diane Sindel, receiving a life sentence. The prosecution's case heavily relied on bite mark analysis, with an odontologist testifying that marks matched Sullivan's dental records. Central to the case was bite mark evidence. At the time, forensic odontologists asserted that bite marks were as unique as fingerprints, leading to the conclusion that Sullivan's dental pattern matched the marks on Miss Sindel's body. However, the reliability of the bite mark analysis has since been widely discredited within the forensic science community. Critics argued that skin is not a reliable medium for bite mark identification due to its elasticity and the potential for distortion. A 2019 appeal highlighted these concerns, but the Court of Appeal dismissed it, stating that the bite mark evidence was not central to the conviction. In 2021, DNA testing of samples collected at the crime scene revealed a profile that did not match Sullivan. This discovery prompted the CCRC to refer the case to the Court of Appeal for a comprehensive review. The presence of unidentified DNA at the crime scene raises significant doubts about Sullivan's involvement in the murder. All three cases reveal critical flaws in the use of expert evidence in criminal trials. Colin Norris shows how evolving science can expose the fragility of earlier expert claims. Letby demonstrates how ambiguous expert testimony can tip a trial without direct evidence. Sullivan serves as a stark reminder of the potential for miscarriages of justice when forensic evidence is misapplied, and highlights the need for continual re-evaluation of forensic methodologies. Together, these cases have reignited concerns over recurring systemic issues. The use of ambiguous medical evidence, adversarial clashes between expert witnesses, and a troubling dependence on contested scientific claims. This debate echoes earlier discussions following the cases of Sally Clark and Angela Cannings. The Sally Clark case in particular represented more than an isolated error. It exposed a failure across multiple levels of the criminal justice system. It's tempting to place blame on a single expert, but doing so overlooks the deeper systemic flaws. Without broader procedural reform, the criminal justice system risks repeating the very miscarriages of justice it claims to guard against. To restore confidence and ensure fairer outcomes, the justice system must improve its methods for vetting, presenting, and evaluating expert evidence, and must accept that accountability lies not just with expert witnesses, but with the entire legal frameworks that enables their use in court. So, as we were saying, this ongoing debate closely mirrors the concerns raised in the aftermath of the Sally Clark and Angela Cannings cases, which exposed the critical weaknesses in the way the criminal justice system handles expert evidence. Those earlier miscarriages of justice underscored the urgent need for systemic reform, not only in how expert witnesses are selected and vetted, but also in how their testimony is presented, scrutinized, and interpreted by courts. At the time, there was widespread acknowledgement that the system had failed to adequately safeguard against unreliable or misunderstood scientific claims. Yet, despite the lessons those cases offered, many of the fundamental problems were never fully addressed. The reform that were proposed either lacked implementation or failed to take root in practice. As a result, we now face the same structural vulnerabilities, only with greater consequences, as seen in more recent cases like that of Letby. The persistence of these issues suggests not just the isolated oversight, but a deep-seated institutional inertia, one that continues to jeopardize the fairness and reliability of criminal trials involving complex scientific or medical evidence. On the 29th of March 2005, the House of Commons Science and Technology Committee published its report titled Forensic Science on Trial. Although the primary focus of that report was to examine the potential impact of the government's proposal to restructure the then Forensic Science Service, the FSS, into a public-private partnership, which we explored in this video, the report also touched on critical shortcomings in the use and regulation of expert evidence. The report report concluded, we have made a number of recommendations that we believe could improve the quality and treatment of expert evidence and decrease the potential for miscarriages of justice due to flawed expert evidence. These include greater scientific input and oversight through the establishment of both a scientific review committee within the Criminal Cases Review Commission and a Science and the Law Forum, increased use of pre-trial hearings in line with the criminal procedure rules, and forensic and process training for all those involved in the criminal justice system as a condition of the role. Prompted by the finding of the Science and Technology Committee, the Law Commission shared the committee's concern that expert opinion evidence was being admitted into criminal trials too easily and without adequate scrutiny. In response, it launched a public consultation between April and July 2009 on the admissibility of expert evidence in criminal proceedings in England and Wales, which culminated in a comprehensive report published in 2011. Having highlighted a series of miscarriages of justice, including the Sally Clark and Angela Canning's cases, the Law Commission explained that the common law approach to admissibility of evidence is one of laissez-faire, with such evidence being admitted without sufficient regard to whether or not it is sufficiently reliable to be considered by a jury. The Law Commission say we concluded that this is unsatisfactory and proposed that the common law approach should be replaced by a new admissibility test set out in primary legislation. There were in particular a few remarks within the Law Commission report which sound so current. For example, the Law Commission reported a comment by the then Director of Service Prosecutions, Bruce Halder KC. He said, "My own practitioner's experience is that some charlatans or certainly biased and even incompetent experts still exist in the field of science and also in forensic accountancy. The decision of the Court of Appeal that have underlined the independent role of the expert and where their prime duty lies have not always been heeded, and a market still exists for opinions that assist the cause of the paymaster and insufficiently scrutinize the value of the evidence that points away from the conclusions contended for at trial. There must be greater scrutiny of expert evidence at the admissibility stage more generally, and the parties and judiciary should be provided with the information they need to challenge and assess the trustworthiness of such evidence and the individuals called to provide it before it is placed before a jury in a criminal trial. It is for this reason that we recommend in Part 7 a strengthened disclosure regime with respect to expert witnesses and their evidence. In short, the 2011 Law Commission report made 5 key recommendations that could have transformed how expert evidence works in criminal trials. 1. A statutory reliability test. Judges would become gatekeepers required to test whether an expert's opinion is actually reliable before allowing it in court. These mirrors the Dibert standard used in the US and would ask, is the theory or method scientifically valid? Has it been correctly applied to the case? Is the expert impartial and properly qualified? 2. Codified criteria for reliability. No more guesswork. The report proposed specific factors judges must use to test reliability. Can the technique be tested? Has it been peer reviewed? What's the known error rate? Is it generally accepted in the relevant field? Is the reasoning sound and supported by evidence? 3. Judicial training. The Law Commission knew that scientific literacy was crucial. It recommended ongoing training for judges to better understand the medical and technical evidence. 4. Duty of impartiality. Experts should serve the court, not the side that hired them. The report reinforced this core duty of neutrality. 5. Pre-trial expert agreements. To save time and cut confusion, it encouraged expert witnesses to agree in advance where they do and don't see eye to eye. So what happened? Nothing. The government decided that the existing criminal procedure rules and case law were enough, but critics warned that criminal procedure rules don't have the statutory weight or rigor needed to filter out bad science. And then came Lucy Letby. Now, more than ever, the concerns first raised by the Law Commission over a decade ago feel increasingly urgent and strikingly relevant. However, while we acknowledge that implementing the Law Commission's recommendations would have been a significant improvement over the current approach, we remain concerned that even those proposals placed too much discretion in the hands of judges. Judges, after all, are not trained in scientific or medical disciplines, and expecting them to assess complex expert evidence without specialized support risks undermining fairness for both parties. In our view, the judiciary must be willing to set aside institutional pride and actively seek informed guidance from experts in the relevant scientific and medical fields. We explored this concern in depth in our video aptly titled Court of Appeal or Super Expert, where we offered a candid critique of the Court of Appeal's troubling treatment of Dr. Shu Lee during Lucy Letby's first application for leave to appeal. We believe a more appropriate and constructive response will be 1. The establishment of an independent expert evidence council, a national body to vet, accredit and provide guidance on expert witnesses and scientific methods. These shifts authority from individual judges to a regulated expert-led institution which can issue guidance, maintains registries and flag unreliable methodologies. 2. Mandatory joint or court-appointed experts. Require use of joint experts agreed upon by both parties. These would reduce adversarial bias and remove the burden of reliability assessment from a single judge. 3. Clear statutory criteria, not judicial discretion. Codify a statutory reliability test with fixed criteria, for example, peer review, testability, error rate, inspired by the US Dobert standard model, but applied uniformly. This would limit arbitrary decision making by judges and anchors admissibility in objective standards. 4. Expert advisors to the court, not the judge alone. Let courts appoint scientific advisors or panels in complex cases, not for fact-finding, but to help interpret conflicting expert testimony. This would create a shared responsibility between judges and advisors, enhancing both understanding and legitimacy. 5. Jury aid and scientific explainers. Use vetted visual aids, glossary, or third-party explainers to support jury comprehension. These would empower juries to engage with expert evidence more critically, reducing reliance on judicial summaries. 6. Post-conviction review panel. Establish a specialist appellate body or panel to re-evaluate cases involving questionable expert evidence. These would prevent individual judges from acting as an accountable gatekeepers at trial with no oversight. Reforming expert evidence isn't just a matter of cleaning up courtroom science. It's about truth. It's about accountability. It's about justice. Delayed for some, denied for too many. For every conviction built on flawed testimony, there is a life shattered, a family broken, a system compromised. The Law Commission showed us a path forward over a decade ago. We ignored the warnings. Now, in the wake of the Lucy Letby trial and others like it, we can no longer afford to look away. Reform isn't optional. It's urgent. It's not just a technical fix. It's a moral imperative, because when expert evidence fails, justice fails with it. These are our views. And what are yours? Drop your thoughts in the comments below. We want to hear from you. And if this video challenged you or taught you something, hit like, subscribe and share it. Finally, join us next time as we once again sit and rise in this unique trial.